Hi there, I'm Godwin Salasidapo, and this is Make It Legal. Today, I'm going to reveal the only reason why your marriage is either void, voidable, or valid under Ghanaian law. Make it legal. The verdict as to the status of your marriage will be pronounced either when there's a problem to the marriage or when either party is dead. The court will declare that the marriage is void, voidable, or invalid. Marriages are important and their validity are equally important to the very enjoyment of marriages. So aside validity of marriages that are commonly known to all of us, that a marriage is valid and is proper and it's being enjoyed by the parties, we can also have marriages that are void in law. They are contracted as marriages, but the law could see them or view them as void marriages. And we also have marriages that are called voidable. They could be contracted under the law as valid marriages, but the law will classify them as voidable marriages. Now, let me explain what those two key words mean. What does the word voidable mean? Voidable simply refers to what it sounds like. It is voidable, or it is to be voided. So when we say it's voidable to the lawyer, voidable simply refers to a marriage which is valid until it is declared to be invalid later. A marriage which is now valid because the parties are not challenging the validity, it will be construed as valid so long as they are not challenging that it is invalid. But the day either party decides to seek to have it declared invalid, the court will say that yes, it was voidable, so it could be declared invalid today. Now, we also have void marriages. Void marriages are marriages that are invalid from the very onset and should be declared as such. In other words, they are invalid, they are not in accordance with the law, they are contrary to how the law expects it to be, and the court will declare them to be void, and void ab initio. That is a lawyer's term you should know. It means from the very beginning it is void. Now, let me share with you 5 key things that you can use to determine whether or not a marriage is void, or the circumstances under which the law will say that this marriage is void in law. In other words, it has always been invalid and cannot be respected as a proper marriage between the parties, regardless of what people have done before the time of declaration that is void, regardless of who they are, whether they are professors, they are lawyers, they are doctors. If the court is not satisfied with all of these things, the court will say it is void. I'm sharing 5 of them with you. The first one is that the marriage was celebrated at the wrong place of celebration of marriage. Now, the law has specific places registered or recognized by law that you can celebrate your marriage for it to be valid. And we are talking about ordinance marriages here. In other words, if you have not celebrated your marriage at these licensed places, the law can regard your marriage as invalid or void. So marriages could be celebrated at 2 places. We are talking about ordinance marriages, don't forget that. Number 1 is that you could celebrate it at a licensed place of worship. Number 2 is that you could celebrate it at the office of the registrar of marriages or at the marriage officer's office. Now, if you don't celebrate your ordinance marriage at any of these 2 places, then the bad news, unfortunately, is that that marriage is invalid and is void in law. You may not know it today because both of you are just having a normal life, enjoying marriage. But when issues come, the court will delve into the marriage, and one person will bring out how it was celebrated, and they will declare it to be invalid. So if you get to know that your marriage is void, what can you be doing? Rush, speak to a lawyer and get guidance. The only basis where you could celebrate a marriage at a place that is not a licensed place of worship or the office of the registrar of marriages is because the registrar of marriages has given you authorization to celebrate at a place other than a licensed place of worship or the office of the registrar of marriages. Now, that leads me to the second point. This is the next point under which the court could declare a marriage void. Hope you're enjoying this video so far. Don't forget to subscribe to this channel. Subscribe to Make It Legal channel. There's a subscription button there. Click it. When you are done, like this video and click on share to share with a friend. That is if the marriage is celebrated without certificate of notice. All ordinance marriages can only be celebrated after the parties involved have gone through an application of bans, and then the registrar or the marriage officer gave them a certificate of notice. That is a certificate showing that they have complied with the requirement to give notice and have bans published. It is only when that is done that they can go ahead to celebrate the marriage. Now, you can celebrate the marriage. There are three certificates. Let me list them for you. Number one is the Registrar of Marriage certificate. Number two is the Marriage Officer certificate. Number three is a special license. Now, under these three licenses, you can have a valid ordinance marriage. When they issue this license to you, you have 3 months to celebrate the marriage. Without any of these licenses, no matter the marriage, no matter the age of the marriage, no matter the children of the marriage, no matter the caliber of persons who are in the marriage, it is void. It is void unless you get any of these certificate of notice to have your marriage celebrated at the right place of celebration. Your marriage is void according to the law. The third point I need you to note is that the celebration of the marriage must be done by a licensed or recognized minister of religion or the registrar of marriages. If the one who is in charge of the celebration of the marriage, not just the minister who preached on that day, the one who is the official in charge of the whole ceremony, who supervises what is to be done, how the vows are taken and all of that. If that person is not a licensed minister of religion or a recognized minister of religion who has been licensed by the appropriate state institution to officiate marriages or to be able to, supervise celebration of marriages, your marriage is void. You cannot escape that. If this is not fulfilled, when issues come one day, one party who needs to declare that the marriage is void in order to benefit will bring out the fact that shows the marriage is void. And one of the facts could be that the one who celebrated the marriage, the officiating minister who was in charge of the celebration of the marriage, was not a licensed minister of religion or was not the marriage officer. You need to know this. That is a third point you need to note. The fourth one is that the celebration was done under a false name. Now, a false name is a name that is deceptive, a name that is not the official name of the parties. For example, if I am called Kofi Mensah and then I intend to marry Amma, Amma is also called Amma Kweku. When we are going to that marriage, I cannot go using the name like Kwabena Mensah to contract the marriage. It is a false name. It is not my true name. And because I have used the false name, the court will construe the marriage to be invalid. Because, in other words, Amma has actually married someone who is Kwabena Mensah. Meanwhile, I am Kofi Mensah. And that is misrepresentation of facts. The fact based on which the party has married. Of course, every case will be looked at based on its own peculiarities. But it's important to know that you always have to use your official names when you are filling the marriage forms and when you're also going to celebrate the marriage. If you there use a false name, it is a ground for the marriage to be declared void. Please, in case you need specific details as to what these things entail and how it applies to your peculiar case, you don't need to rely on this video alone and reach conclusions. Speak to a lawyer of your choice. He can be of much help to you. I thought I was going to give you all the 5, but I want to reserve one. Those who watch and comment, I'll leave it in the comment section. Get that last one as a bonus from me, just in the comment section. I'm sharing that one in the comment section. Now, closely related to void marriages, that is marriages that are invalid from the beginning throughout the life of the marriage till the end. They are invalid or void. Related to that term is the term voidable, as I explained earlier. When the marriage is voidable, it means that it is valid all along until one party takes steps to say that I no longer want it to be this way. I want it to be declared invalid because I was a child. I was 70 years old when I got married. And as a child, I cannot have a valid marriage. Now that I have become an adult, I think the marriage was contracted when I was 17 years old. It's not valid, therefore the court should declare it invalid. So that marriage is voidable in law. It's voidable in law. Watch my video on the review of Asamoah's case, where I discuss the peculiar circumstances of that case where Gifty Jan was 70 years at the time. She contracted a marriage with another man, and the court declared that marriage to be valid, despite the fact that she was 70 years. Watch that video. I'll leave the link right here. You can watch it, and then you get to appreciate what I mean. So I want to share with you 4 instances under which the court can declare any marriage, when these circumstances are there, to be voidable in law. Please pay attention and use it to check your marriage, your ordinance marriage, I mean. The first one is if the parties have not consummated the marriage since it was contracted, and that lack of consummation is as a result of a party's willful refusal to consummate the marriage. Now, consummation is already explained in one of my videos. You can take a look at it, but I'll explain it again For those who have not watched that video yet, please look for that video and watch it. Now, consummation refers to the first sexual intercourse the parties engage in immediately they marry or after the marriage. So if the parties refuse to have that sexual intercourse, either that first one or throughout the marriage, they've not been able to engage in sexual intercourse properly so called. If they have not done so, and that lack of sexual intercourse is because one party is deliberately refusing to have sex in a marriage, the court will say that the marriage, as it is subsisting, is a voidable marriage. We're just waiting for one day one of you will come and say that, you know what, we never had sex, therefore I'm coming to say it should be declared invalid. The second one is where one party to the marriage is of unsound mind. You are sane and you want to marry someone who is insane. The court will say the marriage you have contracted is valid. But if one party says, you know what, at the time I contracted this marriage, I remember I was told that I was not well in 2022. So how could we have married in 2022? The court will say that, this marriage has to be declared voidable because one of the parties to the marriage at the time it was contracted was not sane. In other words, was insane. Same people should marry same people, not same persons marrying insane people. No. The third one is where the woman who is to be married under the ordinance is now pregnant for someone else. Too bad. If you are pregnant for someone who is not the person you are going to get married to, the court will say that if you continue to get the marriage contracted, ignoring the pregnancy, that marriage is considered in all its lifespan to be voidable and it can one day be declared invalid. The last one is where either party to the marriage, the man or the woman, is suffering from an incurable venereal disease. Remember, it should be incurable. Then the court will go ahead to say that when they contracted a marriage, ignoring that disease, the marriage should be declared voidable. Hope you're enjoying this video so far. Don't forget to subscribe to this channel. Subscribe to Make It Legal channel. See the subscription button there. Click it. When you are done, like this video and click on share to share with a friend. Now, when the marriage remains voidable, what it means is that it is valid and subsisting. All along, the law would deem it to be proper and good to go. So the parties can enjoy all there is to be enjoyed and they would have it valid. Now, when issues come to and they have not dissolved it, or one party is dead, the court will not say because one party is now dead, the marriage all along has been invalid. No, the court will say that it has always been valid between them until one of them comes to court to declare it invalid. In other words, a voidable marriage remains valid between the parties until a step is taken by one side to declare it invalid. Void marriages, on the other hand, are always invalid. And when they are declared invalid by the court, the implication is that it has never existed. My name is Godwin Selassie Dakpo. This is Make It Legal.